2003, Axis 5:1. It says, during any strike or lockout, the employment relationship between the employer and the workers shall not be affected by the strike or lockout or any termination of the contract of employment as a result of the lawful strike or lockout in void. Find me the portion on essential services. Kunzo. I want to read it to them. They are happy. No, essential services. There's a portion on essential services. Essential service providers. Essential service providers. This is what you agreed in the court. We'll find that essential service provider. Kunzo, look for it. Now, these terms of settlement are witnessed as follow. When the psychiatric nurses took you to court, Ghana Registered Nurses and Midwives Association, you paid them a compensation of 100,000 Ghana cedis. This was your terms of agreement. Consent judgment. It's on the screen. Read it. You yourself read it. Your leaders who are taking you on, put it there and let them read it. Your leaders who are taking you on this journey, they went to pay 100,000 Ghana cedis to the psychiatric nurses. What was the genesis of the conversation? They went to sit at a table. They didn't bring the other unions to come and negotiate. The other unions felt that they have been shortchanged. They went to court. The court granted them. Then when the embarrassment was coming, they agreed that we will come together and then we will pay you your money and then we will waive our rights, blah, 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 blah. Now the same people are saying, look, you want to engage the minister, but we want to have a conversation first before we do the implementation. Somebody says, oh, the thing was signed in 2024 and in 2025 it has to be implemented. Now who caused them? When you were going to the table, did you bring the other unions to join you? Or did you think you were so superior that the other unions shouldn't join you and they had no place? It is a court document. I'm not reading from my head. I didn't manufacture this. I'm not manufacturing your consent. Kunzo, find me the thing from essential services. Let's read section 162 of Labor Act 2003, Axis 5:1. It says, in any industrial dispute that affects workers engaged in an essential service, in any industrial dispute that affects the workers engaged in an industrial service, the parties to the dispute shall endeavor to settle the dispute within 3 days of the occurrence of the dispute by negotiation. Today is the 9th. How many days has this been? Ask your leaders. Ask them. And then section 2 says, if after the expiration of the 3 days, the dispute remains unresolved, the parties shall within 24 hours of the expiry of the 3 days refer the dispute to the Commission for Settlement by compulsory arbitration under section 164. Section 3 says, the Commission shall take immediate steps, but not later than 3 days after the dispute has been referred to settle the dispute by compulsory arbitration under section 164. Listen to this one. Section 163 says, prohibition of strike or lockout in respect of essential services. An employer carrying on or a worker engaged in an essential service, which includes nurses, shall not resort to lockout or strike in connection with or in furtherance of any industrial dispute involving the workers in the essential service. The nurses were part of the people that wrote this for us as law in 2003. Why are they misbehaving? Come to me. I say this one, the nurses, what I just read to you, they were part of the group that sat together in a room to write this. So why are they going over and above their own word and disrespecting their own agreement? Have you paused to ask them that question? Have they paused to even ask themselves that question? When this law was written, not many people were nurses.